Social media is affecting the legal process and how jurors are investigated and how jurors receive information regarding potential cases. According to social media statistics on socialeconomics.com, 31% of the 851 million people on social media use Facebook to say where they are, what they are doing, and to list their interests. This information may be used by attorneys in selecting potential jurors. For example, Armando Villalobos, a district attorney in Brownsville, Texas, told the Brownsville Herald in a January 17, 2011 interview he was in favor of checking social media of potential jurors. Brooke Palin of bloggingthelaw.com believes through reviewing social media posts, it creates evidence of time, place, action, and state of mind, especially in divorce cases. The Conrad Murray trial is a key example of attorneys asking jurors to disclose their social media handles and to see if jurors had posted about the doctor's involvement in Michael Jackson's death. Even though some attorneys are in favor of utilizing social media to investigate potential jurors, the New York City Bar has implemented Rules of Conduct 3.5 and Rule 8.4c to limit jury online research. The rules say the communication must not be used in a deceptive manner. The communication must not knowingly cause communication with the juror. The juror must not receive a communication of the research. Attorneys are preparing for this social media juror impact by teaching, writing papers, and preparing presentations to other attorneys. Dallas attorney John Browning presented a CLE to the State Bar of Texas in 2011 where he discussed checking jurors before trial and tweeting from the jury box. Another concern is not only investigating potential jurors, but jurors utilizing social media to discuss cases. According to research from the Federal Judicial Center and research done by eDiscovery Tech Blog, 11 cases in 2010 and 2011 were cited for juror misconduct for use of social media. Several court cases from 2010 to the present show insight on jurors' social media use and how the court has responded to such use. It is evident that the court has responded on a case-by-case basis. As social media continues to impact juror selection and the trial phase of the legal process, one solution is for juror education on the ramifications of utilizing social media during trial and why it should not be done. The Massachusetts Appeals Court has requested judges do a better job at speaking to jurors about internet and social media use. There are 19 states where jury instructions mention social media and online use. On May 12, 2012, the state of California passed a law forbidding jurors from accessing social media online. Jacob Jock of Sarasota, Florida, became the first juror ever to serve a 3-day sentence in jail for contacting the plaintiff via Facebook. A juror in Texas in 2011 was sentenced to 2 days of community service for friending on Facebook as well. Research done in 2011 by the Federal Judicial Report showed 30% of the time the judge removed a juror after media misuse. 3% of the time the jurors were fined or held in contempt. On August 8, 2012, the juror in Corpus Christi who friended the attorney asking about his status if he was single was removed from the jury. Thaddeus Huffmeister, an associate professor of Dayton School of Law in Ohio, and Eric P. Robinson, a contributor to the Citizen Law Project, both agree with juror education. Robinson told the Boston Globe the judge has to explain why it should not be done. Hoffmeister told the Wall Street Journal the same thing. He quoted, "Jurors should be equal partners in the courtroom, and to tell them why they can't do it." But is a juror education a concept attorneys and social media experts will embrace? Or will legal professionals support bar associations regulating such online practices? By interviewing noted experts like attorney John Browning in Dallas, Texas, social media expert Mike D. Merrill, Thaddeus Hoffmeister, and other social media and legal experts, I will examine answers to these questions.